Call the first case on this morning's docket. Case number 103499, Angela Cady v. John Schroll, MD, et al.
May it please the Court? I'm Roger Wright for Plaintiff Appellant Angela Cady. With the Court's permission, I'd like to reserve 5 minutes for rebuttal.
5 minutes is granted.
This case comes before the Court to answer the question as to whether a medical group can be held liable for its own negligence in failing to supervise a physician employee of the group who behaves inappropriately with the female patients of that group. The trial court and the Court of Appeals answered that question no, holding that because of KSA 40-3403H, a statute which provides immunity for vicarious liability or responsibility, that there could be no responsibility of any kind for the employee of a physician. We suggest, Your Honor, that that interpretation by both the trial court and Judge Liebman's opinion in the Court of Appeals violates the rules of grammar, it violates this Court's rules of statutory construction, and it is in conflict with this Court's precedents on the issue of negligent supervision. If Judge Liebman correctly interpreted this Court's precedents, we respectfully suggest that those precedents themselves are incorrect and should be overruled. Our rationale, I'd like to begin with first, is we think this Court has already answered this question and answered it opposite from the way that the trial court and the Court of Appeals answered it. In the case of Glassman v. Costello, cited in the briefs, the issue came before the Court as to whether a surgeon could be responsible for failing to direct, an obstetrician surgeon, failing to direct a nurse anesthetist who is providing anesthesia for that procedure. The nurse anesthetist said no, this statute, which eliminates vicarious liability or responsibility, says there can't be any responsibility of any kind for the failure to appropriately direct. This Court said no, that's not true, that the failure to direct, which is the failure to supervise, is a separate independent act of negligence. It is not vicarious liability. It is not vicarious responsibility. And because of that, there can be liability on behalf of a healthcare provider for his own independent negligence in failing to supervise or direct the healthcare provider who operate underneath him.
In that case, though, there was a statute that imposed a supervisory role upon the physician over a CRNA.
That's true, Your Honor.
What do we have here when we have a physician who is the captain of the ship?
Well, I would suggest, Your Honor, that, and that's the distinction which the trial court, Judge Russell, relied upon in granting this motion. But I would suggest that that's a distinction without a difference, because essentially what happened in Glassman is a statute imposed a statutory obligation to supervise. In this case, the common law of the state of Kansas, as explained in this Court's opinions, imposes a duty to supervise. The duty exists either way. We've never held in any of our cases that the fact that a duty is imposed by statute means it should be interpreted differently than a duty that's imposed by the common law.
Other physicians have a duty to supervise another physician?
That is not the issue in this case, Your Honor. And
why isn't it? It's a medical group.
At the trial court level, it's true, other physicians were sued, and we made the argument that they had an obligation to supervise. That portion of the case has not been appealed. We are not claiming at this point that the physicians had a duty to supervise. We are claiming that
physicians, the shareholders of the corporation, of the medical group?
They are the shareholders, but legally they are distinct and different entities.
I understand, but where does the duty come from a medical corporation to supervise a physician as the captain of the ship?
Well, Your Honor, I would suggest it's not a captain of the ship analysis. The captain of the ship analysis says that a surgeon is responsible for everything that happens in the operating room.
Right.
We are saying...
I understand that. I technically shouldn't have used that. But isn't it the physician that controls the medical care? And what duty does a corporation, which that that physician as a shareholder have to do anything to control the care and treatment that physician is providing?
That corporation, we would submit, has the same duty that any employer has. It has the duty to make sure that its employees are acting appropriately. That corporation has the ability to say, these are the hours you work. That corporation has the ability to say, here's when you need to show up. That corporation has the ability, and medical corporations do all the time, to put in policies and procedures that says, here is the way you are going to operate while you are working for us. It has the opportunity to say, here are the policies and procedures that you're going to follow, and usually their contracts say, you will agree you'll follow best practices in the course of medicine. Even more importantly in this case, this is not a case where we are claiming that the supervision involved had to do with the details of the medical care. Should he have done this type of stitch versus that type of stitch? In this case, the supervision that was necessary was to do exactly what the corporation said it was going to do. They knew after the Board of Healing Arts imposed discipline on him for improper action in connection with female patients, that even after that they received additional complaints from other female patients and employees that he was continuing to do those things. And so what they said is, have a nurse present in the room with you when you're taking care of female patients. Now that doesn't mean that that nurse was there to say, here's the medical diagnosis you should make. It wasn't that type of supervision. The type of supervision that was necessary in this case is the same type of supervision you might give to a law clerk, you might give to a mechanic, you might give to an accountant, you might give to anyone who's going to be placed in a situation with a vulnerable person and you have reason to know, based on his or her past behavior, that he's putting that person at risk. That nurse was in there not to provide medical guidance. Well, she wasn't in there at all. That nurse was supposed to be in there not to provide medical guidance. That nurse was supposed to be in there to make sure that this physician did not continue to engage in improper physical contact and make improper abusive statements to his female patients. And so I think it's a bit of a red herring to suggest, as the defendant has, that this is all about the independent exercise of medical judgment. Instead, I think this is about an employee's or employer's responsibility to make sure that its employees are behaving within the rules of civilized society that we expect of all employees in any profession, whether they're doctors or anything else. So we believe that this court's decision in Glassman v. Costello rules this case, and that the Court of Appeals was in error in failing simply to follow Glassman v. Costello and saying, based upon that opinion, the obligation to supervise exists, and that in this particular situation, the case should have gone forward to trial. Secondly, the Court of Appeals seized upon some fairly broad language in the McKay and Lima's opinions, which would suggest, if interpreted literally, that there could never be any liability of any kind, whether it's vicarious or otherwise, for a physician's group that employs a physician. And we would suggest that that's a misinterpretation of this court's prior opinions. Just a year after Limoges was decided, this court handed down its decision in Alderati. And in Alderati, this court made it clear that those earlier decisions were supposed to be limited to the context of corporate negligence claims. And the court defined what a corporate negligence claim is. It defined that to be a claim seeking to hold a hospital, not a medical group as we have in this case, responsibility for the actions of an independent contractor, not an employee as we have in this case. And so under Alderati, the purpose of this statute, properly construed, and the meaning of those two previous cases was, we don't have corporate negligence claims in the state of Kansas. Since this is not a corporate negligence claim, those decisions don't properly control in this case. And so the court should have followed the Alderati opinion as well as the Glassman opinion to hold that negligent supervision does exist.
The difficulty, I think, is that Alderati also used some extremely broad language in talking about corporate negligence, which encompasses a lot more than the facts of that case did. And in fact, in McVeigh, this court had described corporate negligence in broader terms than Alderati did. And so we're left kind of with a disconnect even in terms of the terminology that were used between the two cases and trying to decide what the court meant in Alderati, aren't we?
I agree the language was different. I would suggest that chronologically we can read Alderati to narrow McVeigh because it knew what came before and interpreted it in accordance with that. And so I think the language in Alderati I think is more properly correct. And finally, that kind of leads into the last issue, which is the language in McVeigh is so broad that it is broader than the language of the statute itself. McVeigh had to rewrite the statute in order to reach the opinion that it reached. In McVeigh, the court said that a healthcare provider, in that case a hospital, could not be vicariously liable or otherwise responsible. The statute says nothing about being otherwise responsible. It says vicariously liable or responsible. I see my time's up.
Do we have any further questions of counsel? Thank you, counsel.
May it please your court. Your Honors, my name is B.K. Christopher, and along with John McEntee, we represent the Applee Women's Care Professional Association. I believe that the ultimate question today is whether women's care as a professional medical group is responsible for the acts of a physician, Dr. John Schroll, and we believe the answer to this question is no.
So if you were a pediatric clinic, it's okay if you hire pedophiles to work in your
I would
facility?
suggest that it's never appropriate to have pedophiles provide care.
But you wouldn't be liable.
No,
for what
here's
they did.
here's the distinction I would make, Your Honor. I think that the obligation, the supervision of physicians, they are independent licensees. I think the Kansas Board of Healing Arts is the organization that oversees and supervises and makes sure that a physician is appropriately licensed. I think what's been mischaracterized here is the Board of Healing Arts never took any limitations on Dr. Schroll's licensure. They didn't. They didn't limit the patients he could see. They didn't tell him he needed to have a mentor, which they can at times do. They put no restrictions whatsoever on Dr. Schroll's licensure. So as far as Women's Care Professional Association was concerned, he had been, although they had fined Dr. Schroll and said that he had made some inappropriate comments and remarks, they had never found that that his licensure or his ability to practice medicine should be in any way limited.
So your answer to my question is no, the clinic has no liability. This all has to be taken care of through the licensing board.
My position to you, Your Honor, would be that a medical group does not have a duty to supervise physicians who are independent licensees who have licensure established by the Kansas Board of Healing Arts. My position would be that the appropriate entity in the state of Kansas to supervise and oversee physician conduct is the Kansas Board of Healing Arts. That's why it was established. That's what they do, and they do it quite well.
What about their duty to supervise their employees?
I think that's different because
That's different.
Right. I think it's different under 403403H because employees of a medical group are not healthcare providers as defined by the statute. And as we are aware, back in the mid-'70s, there was a concern about a medical malpractice crisis in Kansas, in the state of Kansas, and the availability of physicians to provide care if malpractice premiums went through the roof. And the legislature enacted the Health Care Provider Insurance Availability Act, which created the fund, which created the statute. And it's worked quite well. We are become a model for other states to follow. And I do believe my group, would have a responsibility to supervise employees, nurses, technicians, receptionists for their behavior and their acts.
Whose idea was it to have a nurse in the room with Dr. Schroll during examinations of his patients?
What I have come to learn from this case, Your Honor, is that younger OBGYNs typically do that now as a matter of course and training. They will ask for a nurse to be in the room to chaperone. That older physicians, that wasn't the way they were trained as far as in obstetrics and gynecology, and that after the Board of Healing Arts had cleared Dr. Schroll, the group still was concerned, and they asked for him to be independently assessed by psychiatrists, and then they made a suggestion to him that he should have a chaperone or a nurse in the room when he saw patients.
So Women's Care made that determination, is that right?
I'm not sure who specifically. There was a letter that was sent to Dr. as far as if it was a physician, if it was the group as a whole, there was a letter sent to Dr. Schroll making suggestions that he would need to be independently evaluated by a psychiatrist, and that they made a suggestion that he have a nurse in the room with him when he saw patients.
And what was the letterhead for
It was
that
Women's
communique?
Care. It was from the professional corporation, Your Honor.
And your characterization of that was it was merely a suggestion, it was not any type of a requirement?
They didn't put into place an absolute requirement that he would have to have. Like, they didn't establish a protocol for him to do that. It was made that they would like for him to do that.
We request that a nurse be present during all of your patient examinations, whether such patients are new or continuing patients of the practice.
Right.
I just wanted to clarify what that was.
I'm sorry, I didn't have that letter right in front of me, Your Honor, but that was my understanding, was that it was suggested to him that would be good practice to do. And the interesting thing I will point out from a factual perspective is that on one of these alleged incidents, they claim that her father was in the room, which makes me wonder, what would a nurse do if a father, who is probably the ultimate protector of a child, didn't notice that anything untoward was going on and didn't stop this alleged inappropriate conduct?
And the request by Women's Care that Dr. Schroll have a nurse present during all the examinations, can that be characterized as an assumption?
I do not believe so, Your Honor. I do not believe that Women's Care created a duty or assumed a duty by making that request. I think it would be no different than saying, which groups can do, you need to try to be to the OR on time. You need to try to get here to see your patients and not have a waiting room full of patients. I don't think that means then that Women's Care, as a professional organization of physicians, any different than I'm in a law practice, I have partners. I don't have an obligation to tell my partners what to do or how to do it or how to maintain their cases. I work with them in a professional corporation. I can make suggestions to them that I think would be helpful. That I think
Can
would
they
be
direct
good.
you to keep your hands off your clients when you're alone with them in your room?
I would suggest that I've never thought of that, but I would suggest that it would be appropriate if I was acting inappropriately in the eyes of my partners to suggest that I not do something that they felt was inappropriate.
And you would be free to say, I'm not going to comply with your request.
I think I have independent volition to act, as I'm an independent licensed physician, and that if I thought that was in the best interest of my practice to do so, which I wouldn't suggest it is, but I don't think my partners can necessarily be in the room or be in the courtroom to oversee everything that I do and say or act with my clients. I think I have my own obligations as a licensed holder of a law license in this state to act in accordance with the standards and the guidelines and practice and ethics of my profession. And I think Dr. Schroll had that same responsibility. He is an independent actor, independent licensed physician. I believe he has an obligation. I don't believe it's Women's Care's responsibility as a professional group to supervise him. In my position, Your Honor, would be that 403403H basically establishes that the group, as a healthcare provider, cannot be vicariously liable or responsible for the acts of Dr. Schroll, because without Dr. Schroll's conduct in this case, without whatever inappropriate comments, touchings, there could be nothing for the group to supervise. It arises out of Dr. Schroll's conduct. So absent Dr. Schroll's conduct, there would be nothing for us to supervise.
The thing that seems to me that this case is blurring concepts. Most of what you seem to have talked about this morning is that you have no duty. Women's Care had no duty to do these things that are being alleged. And yet you've tried to tuck it under vicarious liability, which is a different argument. And I think because they all get stirred together as part of the problem that at least I'm having conceptually with the arguments that are being made today.
Here's how I see it, and maybe this has helped me get clarity on it. Obviously, the cases, the McVeigh, the Lemieux, Alderete, those are all cases that were primarily addressing corporate negligence. But they give us a good analytical framework to interpret this statute, to look at 403403H. And my position would be, it's been well established that one healthcare provider cannot be vicariously liable for another healthcare provider. I think where this case falls is in the portion of the statute that says, or responsibility. No vicarious liability or responsibility.
But I thought I read your brief to say that you thought vicarious it was vicarious responsibility as well, that vicarious modified both words.
I think they put in their brief was that at the Court of Appeals, I said vicarious could modify both. The way I look at it is that the vicarious liability is one aspect or responsibility, and it all is vicarious behavior. But if you allow a negligent supervision claim like this, you will basically eviscerate the purpose of the statute, because all that will happen is everyone will come in and try to plead around vicarious liability and plead negligent supervision, and then we will have professional groups being on the hook for physicians when that clearly was not the intent of the legislature. They clearly did not want one healthcare provider to be responsible for another healthcare provider. In fact, the case that you brought up, the Alderete case, I believe is the Glassman case, I believe is absolutely distinguishable, because there is a separate statute. It's 65-1158 that requires a CRNA to be supervised by a physician. And so the OBGYN is required by statute to supervise a CRNA, because a CRNA is not a physician, it's a nurse. And it's a nurse anesthetist who needs a physician to direct and control their care. That's by statutory language. There is no such language here.
Ms. Christopher, you would agree with us that the Act is in derogation of the common laws that existed at the time the Act was passed, right?
Yes, absolutely. Yes,
and so
common law
prior
is,
to the Act, a group such as yours would have vicarious liability for the physician employee.
Absolutely. There's no dispute that the statute basically...
Given that,
yes.
Is that distinction from Glassman really sound? You're saying, you have to have a statute that gives responsibility.
I'm not sure I'm following, Your Honor. I'm sorry.
I think what you just told us is Glassman's completely distinct.
Right.
Because there's a specific statute giving the physician supervisory responsibility for the CRNA.
Correct.
And so I'm asking if that's really true. If we were to find that this is limited to vicarious liability or hold that this is limited to vicarious liability, which is a term of art,
right,
as opposed to just general responsibility of any sort, including supervisory, then we would return to whatever the law was on supervisory responsibility prior to the enactment of the Act, to the common law, correct?
That's correct. We would go back.
And then your distinction from the Glassman case evaporates, does it not?
Yes, then yes, that's correct. I'm sorry,
I just wanted to make sure that
not to be slow. I'm sorry. What I really feel like is this is just an inroad. Dr. Schroll settled this case. This is just an inroad to try to get another healthcare provider to be responsible for this healthcare provider, and
it's only permissible if the Act permits it.
Right.
And that's what we're trying to figure out. And it really comes down to how we read that word responsibility.
Right. Or responsibility. It's no vicarious liability or responsibility. And I believe that if this court looks at its prior opinions of McVeigh and Lemieux, it's that you guys have, in two opinions, have already established what responsibility means. And we have a good framework to look at there, that what responsibility, there's no reason to modify the understanding of the word responsibility that's been consistently found in two opinions. And after those two opinions, I believe it's also important to note, and those were in, if I'm correct, 93 and 97, the legislature did not modify after these decisions. The Kansas legislature did not come back and say, no, the Supreme Court got it wrong. We don't want this interpretation of responsibility. And I would also suggest, Your Honors, that this interpretation of responsibility is absolutely in line with the broad purpose, as I mentioned earlier in my argument, of the Healthcare Provider Availability Act that has really kept physicians in rural areas in Kansas, kept malpractice premiums down, and has given us an excellent model of delivery of health care in this state.
If this physician was harassing one of the employees, sexual harassment, and the other physicians were aware of it, and either didn't do anything about it or didn't act sufficiently somehow, would the corporation have a duty, and could they violate that duty by not taking action?
I believe absolutely they could, because I think what the difference here is the Healthcare Provider Availability Act modified common law causes of actions. The legislature took steps. They took away vicarious liability, which is present at common law.
That's not vicarious liability. That's negligent supervision.
No. I'm agreeing with you, Your Honor. I'm saying I believe that the statute, as set forth, also. That's why there's no negligent supervision case that we can point to for a healthcare provider. There's never been one in the state of Kansas. I agree at common law there is a negligent supervision cause of action. You guys upheld it in the Marquis decision. I absolutely agree that cause of action exists at common law.
I'm asking if in a different setting, not a patient, physician-patient.
And I agree with you that under the sexual harassment,
this statute would have nothing to do with that.
Nothing to do with sexual harassment.
And they wouldn't be protected.
They wouldn't be protected
from any kind of normal employer-employee type.
Absolutely not, Your Honor. And I believe the distinction here is that healthcare providers are treated differently when it's two healthcare providers under the Healthcare Provider Availability Act in this statute. I don't.
No, I don't.
Okay.
I don't see what you mean.
I agree with you absolutely.
So they would have responsibility for his harassment of a fellow employee, but not, even if they knew about his harassment of a patient, they'd have no responsibility because that's because healthcare, or it's arising out of.
Yes, arising out of the conduct of Dr.
So it's really
Schroll.
the arising out of that makes this different.
Yes. And it's also because the statute holds that no healthcare provider can be responsible for vicariously liable or responsible for any injury or death arising out of the rendering of or the failure to render services. And there's no dispute that Women's Care is a qualified healthcare provider and that Dr. Schroll is a qualified healthcare provider. So I believe this really isn't about, truthfully, I don't believe this is about negligent supervision. I believe this is about the statutory interpretation of KSA 40-3403B. And I believe that healthcare providers under that statute are treated differently because the legislature enacted this statute.
What about, isn't there an exception for sexual behavior?
I always want to say plaintiffs, Your Honors, and I'm sorry. The appellants brought up that argument at the Court of Appeals, and that was never, ever brought forth at the trial court level. I would suggest that this was specifically pled, this petition, this 14-page petition, as trying not to characterize these as sexual acts because they did not want to plead themselves out of coverage. And so I think they've tried to straddle the fence. They wanted there to be coverage. They wanted them to be healthcare providers under the fund because they wanted there to be money to pay any alleged damages or injuries. But yet they didn't want it to be categorized as sexual misconduct or sexual acts because that would plead them out of coverage. And so,
coverage beyond whatever his personal resources could pay.
Exactly.
And that's the same reason we wouldn't plead a battery.
Right. There was no battery pled here. There was no sexual assault pled here. And in fact, at the trial court level, Rita Knoll, who is the senior attorney for the Healthcare Stabilization Fund, provided an affidavit that Judge Russell and Judge Haber relied upon that they are both qualified for fund coverage. And they both are. It doesn't mean you have to have coverage. The statute states qualified for it. It specifically says qualified for coverage under the fund. And they both meet that requirement.
Counsel,
I'm sorry, go ahead.
what would your position be if the Angela Cady in this case was not only a patient, but she also was an employee of Women's Care?
I've never thought about that, Your Honor, to be perfectly frank with you. I think that the context of an employee, like Your Honor Moritz brought up over here, I believe it is different. I believe at common law, those causes of action survive, and an employee would still be able to pursue the group for that behavior. I don't know that they could if it was out of health care, if that makes sense. So if they're like,
sorry, if it was what?
If it was out of the health care provided, like Judge Moritz brought up about sexual harassment, I believe that an employee would still have a right to pursue a cause of action against the employer, even if it was a health care provider, for sexual harassment. I think the difference here is the providing of health care.
So it's arising out of the health care. So
Yes.
if a nurse who was employed by Women's Care felt that he or she, I guess it'd have to be she in this case, was the victim of improper conduct by Dr. Schroll,
I believe that she couldn't pursue the group for the health care provided, but she potentially could pursue if she had a separate claim for instance, sexual harassment, Your Honor, that she could pursue. So she could have two different, I think for the claims of medical negligence, that the group would not be vicariously liable for the independent rendering of health care by the physician, but if she had a separate count or claim for sexual harassment for alleged misconduct, that the group could be responsible.
So under some of the facts of this case, where it was basically, bear with me while we have a dress rehearsal of your delivery, that's one of the complaints, is that right?
That's one of the allegations made, Your Honor. That's correct.
In that instance, and it was a nurse who was also the patient, how would you characterize that? Would that be covered by this or not?
I believe it was, if those comments were made in the rendering of health care and it was pled as a medical negligence action, the nurse would not be able to pursue the corporation because the statute, I believe, prevents that from happening.
So regardless of what's being done, as long as it's arising out of this health care, you're just out of luck.
That's correct, Your Honor, because it's not that you're out of luck. You have other remedies. You could plead a cause of action for sexual harassment or misconduct that I don't believe would prevent. It just means that as pled, if you simply plead it as a medical negligence or in the context of providing medical care and treatment, then it would prevent you from pursuing the medical group for responsibility for the acts of...
Just as a general question, is that what you believe the legislature had in mind in the mid-'80s when they were looking at tort reform and passed this act?
Your Honor, I do believe that what the legislature was trying to do was to make sure, in essence, because living where I live, we practice on both sides of the states, and in Missouri, consistently, the group is named the doctor's name, and what happens is those claims drive up in value because they want money from the doctor and they want money from the corp, even if it's just a vicarious liability claim, and it makes those cases have more value even though they shouldn't, and drives up the cost of premiums. And physicians' premiums are higher in Missouri than they are Kansas. And what Kansas has done is said, essentially, I believe, is you can't double dip. If your cause of action is against a physician for the physician's misconduct, for the physician's alleged medical negligence, that is the person you pursue. Because if we allow groups to be vicarious liable or otherwise responsible, basically we're going to have verdicts go up, settlements go up, we're going to make premiums go up, and we're going to force doctors out of this state because they're not going to be able to afford, especially OBGYNs, afford to be able to be insured here. And we won't have doctors that will be able to practice here, which is what other states have faced. And so I would suggest to you that this has worked exceptionally well, and that other states actually come in and look at the state of Kansas as a model for how to keep physicians in the state, keep patients and consumers protected and having money and coverage. And because in some states, Your Honors, the doctors just don't carry insurance coverage. The fund ensures that there's actually a basis for patients who have been victims of medical negligence to have a source to be compensated for their injuries. So I believe the system works exceedingly well. And I do believe that the overall overarching purpose was to make sure that physicians could stay here, to make sure that when consumers, patients were injured, that there was a source for them to seek damages or get remuneration for their injuries. And it's worked.
I understand your argument with respect to vicarious liability, but I can't think that the legislature intended to completely relieve a physician of liability when they have direct knowledge or knew or should have known of some action by one of their physician employees that requires their attention. And essentially what you're arguing today is makes no difference whether they didn't know anything about it and had no reason to know anything about it, or whether they did know, they have no responsibility either way because it's somebody else's problem. And I can't imagine that that's really what...
I don't agree that if that's how I've come across, that's not what... I don't believe it doesn't matter. What I believe is that the Kansas Board of Healing Arts is the absolute appropriate entity to sanction, to discipline,
I don't disagree with that.
Modify.
But we're talking about what they knew or should have known, and not what the Kansas Board of Healing Arts knew or should have known.
But there's nothing that Women's Care knew that was different than what the Board of Healing Arts knew, Your Honor.
Let's take a different scenario then. Let's
Okay.
say the Board of Healing Arts had no idea about this going on, but the corporation did and the other physicians did. And what you seem to be saying is, even though they knew or should have known it was going on, They have no responsibility because it's somebody else's job to monitor that physician.
I don't believe a physician is responsible for supervising another physician. I believe that the rules of professional conduct, just as you and I are lawyers, would require those physicians to report that physician to the Kansas Board of Healing Arts immediately to make sure that the Board of Healing Arts was aware of what their knowledge was and to take appropriate steps.
Okay. Not to fire him or otherwise discipline him in the workplace.
Well,
They can let him continue with impunity in their workplace with no liability.
or I don't know that to proceed in the workplace without any restrictions. I think
Well, they made a request,
right.
but apparently didn't follow up on the
several
request.
requests.
Yes. They made a request that he have a nurse in the room, and they made a request that he do certain things, have a psych exam. Why did they do that if they have absolutely no power?
Well, I think as when you're shareholders in a corporation and you work together, you can say to your other, like I said earlier, I think my partners could say to me, I don't think this is good conduct.
And if he said, I'm not going to have a psych exam, I'm not going to have a nurse, go screw yourself.
That it would be up to them to determine if they wanted to ask him to leave the group or if they wanted
But
him
they
to.
did have that power.
Yeah, I mean, you can ask
But that power carries with it no responsibility.
I think that carries a responsibility to each other in a professional corporation. I believe that because it was arising out of medical care and conduct and treatment, that Dr. Schroll is the person who's responsible for that conduct, not the corporation. What if the corporation didn't know about it? So what if the situation is doctors go into rooms, doctors see patients, how's that any different if it's not? Take away the sexual nature of it, because it seems to me
I don't even care if you take that away. If they don't know about it, you're in a completely different kettle of fish.
But
here we have obvious evidence that they knew.
But then what will happen is people will say, well, it's reasonably foreseeable to suggest that the physician will use latex gloves when they shouldn't be. So group, you're responsible, and basically then we're back to groups are on the hook. We've basically eviscerated there will be basically every plaintiff's lawyer in this state will plead around vicarious liability and argue negligent supervision, and the courts will have ham tied if this is what we uphold and have to say fine, that's a cause of action.
It's a policy argument. What we're really here about today is what does the statute mean?
Right, and I believe the statute says, and that's what I went back to, is I believe that this is about the interpretation of the statute, and I believe the statute clearly provides if they just wanted to be no vicarious liability, why did they just say no vicarious liability? Why did they put or responsibility? There was obviously a broader purpose than just to prohibit vicarious liability. It says no vicarious liability or responsibility. And so I don't think the legislative intent was just to abolish the cause of action at common law of vicarious liability.
I'm sorry, go ahead.
I was going to say, is there any limit on the egregiousness of the conduct that a physician could inflict upon a patient in which women's care would be responsible under the statute?
I'm sorry, Your Honor, I didn't hear you.
Is there any conduct that you can think of in which women's care would have been liable for a physician's conduct?
If it's arising out of the medical care and treatment of a patient and they're both healthcare providers, I don't believe the group should appropriately, per the statute, be responsible for the acts of that physician. I believe the appropriate cause of action lies in pursuing the physician and having the physician be responsible for his own conduct or her own conduct.
Just so I'm clear to follow this to perhaps an illogical extreme, the letter was written to Dr. Schroll. We ask that you have a nurse present. We ask that you undergo a psychiatric examination. And he says, no, I'm not going to do it. They get a complaint like Angela Cady's. They send him another letter. Please reconsider your decision. He says no. They get a complaint from another person. And so 10 patients down the line, they've said, well, we've asked you to please do this, and you haven't. And you're getting sued and sued and sued, and we're getting dragged into these lawsuits. You're saying even in lawsuit number 10, they would say, we have no responsibility.
Well, I believe the appropriate action there, Your Honor, would not just be in the court system. It would be the scenario you just described, once they got a complaint from a patient, to turn their own physician colleague into the Board of Healing Arts and to allow...
That's independent of my question. We're talking about potential tort liability. I don't care what the Board of Healing Arts is doing about his or her license. So if we can kind of close that door and just look at this one. My hypothetical was, if this happened 10 times to 10 different patients, and they sent out 10 different letters to Dr. Schroll asking, please do this, we request, and he refused, by patient number 10, are you saying they still have no responsibility?
Your Honor, I have a hard time with this scenario, and I'm not trying to be difficult because I don't believe there would be patient number 10. I believe the Kansas Board of Healing Arts would step in after the first one and take action on his licensure. So I don't believe that you would ever get to complaint number 10. But assuming, as Your Honor has set forth the hypothetical, I believe Women's Care could do what they chose at that point. They could say, we don't want you to practice here. If you're going to practice here, these parameters must be in place. But I don't think it would ever get to that point. I really don't. I mean, I think that's why the system works here, because I do believe that and I know you don't want to hear it, but that the entity that is responsible for supervising physician conduct is the licensing agency. And I believe, and physicians.
How does that get compensation or indemnify the aggrieved person? The fact that you take his license away doesn't help this victim.
This victim, alleged victim, I would assert, Your Honor, gets their compensation or remuneration from the physician who is the person acting. That's the person who should be responsible. And that's what happened in this case. Dr. Schroll settled this case. I mean, the victim has not been uncompensated. It's not a situation where Angela Cady is been injured or harmed and doesn't have a place to redress or get remuneration for her injuries or her damages. She's gotten that.
And that's meaningful because of the fund?
Yes, Your Honor.
Did you forward or copy this letter to the Kansas Board of Healing Arts? Do you know?
I don't know, Your Honor, honestly. I don't, because what happened in this case is we were dismissed very early on the motion to dismiss on the first 3 counts, and then the summary judgment that Judge Russell granted. I did then stay in the case as far as producing physicians as they were fact witnesses, and we did produce that document, but it isn't a case that we litigated, so I don't know all the nuances, quite frankly, of what happened after the letter. That letter, if you note, isn't signed. So I don't know if Dr. Schroll agreed to the terms of that, because the letter is not signed, and one of the things was they asked him to sign that he was agreeing to those terms, and it's not signed. So I noticed that last night. So to be honest, I don't want to misrepresent to this court how that went down. I'm not certain.
Really, you're saying that we view the statute as preventing double dipping into the fund.
That's correct.
And so in the Chief Justice's example about the nurse that's getting medical care and also an employee and she gets harassed, the Harassment Act would not fall as something that the fund would insure against.
Absolutely, that's correct, Your Honor.
The bar here is, again, they don't get access to the fund, but if the group has assets or insurance for its normal employer type liability situation, then that's where they'd look.
That's absolutely correct. That's why I was saying it doesn't give that nurse no place to seek redress for the sexual harassment, as Your Honor characterized it, because they could plead that separately, and that would not be covered by the fund, and there would be separate resource. They could pursue the corporation's accounts receivable. They could pursue the whatever remedies or whatever sources were available. Like some carriers now, or some doctors groups and some law groups and lawyers carry coverage for that, for sexual harassment, alleged sexual harassment.
I'm going to have to go back and look because I don't remember and I haven't called it up, but maybe you know. The language in 3403 about arising out of, is that language the same or similar to the parts of the Act that require a doctor to have insurance through the fund? How closely does that language about arising out of the health care?
I'd have to be honest with you, Your Honor, I don't know.
Okay.
I don't want to make any misrepresentations.
Yeah,
I do know, for instance, though, that not everything that you would think of as a healthcare provider is considered a healthcare provider. For instance, nursing homes are not healthcare providers under the fund statute, and so they don't have fund coverage. So I think nurses, for instance, are not, just a basic nurse is not a healthcare provider under the fund language. So it was very specific how the legislature carved out who would have to have fund coverage, because it's kind of a quid pro quo. The healthcare providers have to have some level of fund coverage to afford themselves the protections of this act. And that's all been upheld as constitutional by this court.
Do we have any further questions of counsel? I see you're out of time. Would you like 30 seconds to wrap up, or do you think you've made your points?
I think I've made my point, Your Honor. I would just ask that you affirm the decision of the trial court as well as the Court of Appeals, and I believe that the language of McVeigh and Lemieux give us a good framework to interpret the statute, and I believe this is a question of the statutory interpretation of 4034-3H. Thank you, Your Honors. I appreciate it.
Thank you. You reserve 5 minutes for rebuttal.
Thank you, Your Honor. Women's Care argues that a medical employer has no obligation to supervise because there's simply no duty anytime somebody is independently being supervised under their professional license by a professional licensing organization. In stating the duty concept in that manner, they have essentially eliminated the reason for this statute at all. If there's no duty, there's no need to have a statute that says there's no responsibility. They would also eliminate liability.
Aren't you doing what Justice Luckert said earlier, confusing vicarious liability and your own duty? Because the statute, if it applies to vicarious liability, that would accrue even though you didn't have the independent duty, would it not?
I agree, Your Honor, and I guess my point...
So why wouldn't the purpose of the statute be to eliminate the vicarious liability to the healthcare or the clinic, regardless of its independent duty?
I believe it would, and I was inartful. What I was intending to say is we believe exactly what you said is how it should be interpreted. But if the court was to disagree with us on that and say, no, it eliminates responsibility of any kind, in that circumstance, the statute would end up being a nullity, or that portion of it would, because if there's no duty, there's no responsibility. It would also, if their argument is accepted, it would change the law for any licensed profession. Attorneys are regulated by an administrative board. Architects are registered or regulated. Accountants are regulated. Therapists are regulated. Nurses are regulated. If the answer is there is no duty to supervise your employees if your employees are licensed, then none of those people can be sued for negligent supervision.
But none of those people are required to participate in the fund.
That's true. That's true.
Well,
I'm sorry.
Finish your answer. I'm sorry.
But that's directed to the duty argument they made. The next step is, and I believe for that reason there's absolutely a duty. The next step then gets to the fund argument and what it takes to qualify under this particular statute. And I'm sorry, Your Honor.
And if we agree with you that there absolutely is a duty, then you would read the language of the statute, no vicarious liability or responsibility. You would read the word vicarious to modify only the word liability and not the word responsibility.
No, I mean the exact opposite.
Or the opposite.
I believe vicarious modifies both, and I
You'd
believe...
say it, and so that word, the addition of the word responsibility wasn't intended to address that duty that's out there, right?
Correct. And I
It's a little
believe
confusing, yeah.
counsel asked why would they include the word responsibility in that circumstance. That would just make it redundant. And we pointed out in our supplemental brief exactly why I believe it was included. And that's because the case of Voss versus Bridwell, in which the court eliminated the doctrine of captain of the ship, used the term vicarious responsibility in that case. And so even though it's a vicarious liability, the court just used that term in addition to vicarious liability. And I believe that the drafters of the statute were wanting to make sure it's clear any kind of vicarious issues you might have are eliminated by this statute.
What you're saying is if Ms. Christopher is correct and there is no duty, then there would be no reason to read the statute in the way that she's reading it.
Exactly.
Okay.
Exactly.
I just want to clarify, the question of whether there's a duty isn't before us, is it? Aren't we just looking at if there's immunity under the statute?
Well, that's what I believe.
Okay. I assume the next step of this proceeding, if we would say that there is the possibility of coverage under the statute, that you'll be facing another round of summary judgment motions about whether there was a duty. Wouldn't that be your guess?
That would not surprise me, Your Honor.
But it's
I believe, though, that that's a question that this court's precedents answer fairly clearly, but obviously there's disagreement on that.
It's relevant to the determination of what the legislature intended by the term no vicarious liability or responsibility.
But I think so. For the
Whether
reason
there
I
is
was-
or isn't a duty is relevant to our interpretation of the statute.
I believe so, because if there isn't, for the reason I said, if there wasn't a duty, the interpretation they make would make no sense.
Well, I guess the reason I ask that is I think our case law maybe is clear on duty of employers to supervise employees, for example. But I think it's less clear that there's a duty to warn another a physician's patients that there would be any independent duty to warn, perhaps. So.
And I understand that on remand, we pled a number of different ways in which we believe they violated their failure to supervise. The one that seems to me to be most clear and kind of indisputable under this court's precedents is they have the ability and the obligation to supervise the manner in which the physician is behaving in their office, which would be should have had the nurse present. Now, is it as clear that because they had a separate physician-patient relationship with Ms. Cady, that they had a separate obligation independently to warn her? I believe the law should be that. I'm not going to sit here and tell you that I believe this court's precedents have said that. Does that address the question?
Yeah, it does.
Okay. And again, I see my time is gone.
Do we have any further questions of counsel?
Could I clarify the facts? We had several comments about what's the duty of one doctor to another in a group or whatever. This is a professional corporation.
It is.
And so this doctor was an employee of that corporation.
Yes, sir.
And that corporation had a board of directors and had management personnel involved.
Well, I presume so. We know from the record it had management personnel involved. I don't know that we deposed anyone in their capacity of board of directors, but since they're a corporation, I assume they did.
So the other doctors that are in the clinic are simply shareholders.
True. And co-employees.
And no right to tell someone else what to do any more than I can tell another holder of stock of some corporation I may own.
Which is why we did not appeal the dismissal of the doctors individually. Yes, sir.
Any further questions? Thank you, counsel.
Thank you, Your Honor.
both for your arguments this morning. The court will take this matter under advisement.